6:37, your BBC Radio Wales, and a 75-year-old woman from Flintshire has won a legal claim against the supermarket Asda for age and disability discrimination. Joan Hutchinson from Buckley, who has dementia, was twice asked by her manager if she wanted to retire. Alyssa Thursfield is Head of Employment Law at Gamlin's Law in Shrill. Good morning, Alyssa.
Hi, good morning.
What did Asda do wrong here then?
So when you read the reports about this, you kind of wonder what could Asda really have done. You've got Mrs. Hutchinson, who was presenting as someone who was 73 years old at the time, dementia, getting confused at work, and on the face of it, it looks as though they sort of did what they could and acted in her best interest. But when you dig a little deeper, you find that a lot of what they did was based on presumption because of her age, and that's where they've tripped up here.
Right. So, what should they have done? Because did you get the sense from it what Asda were doing was well-meaning?
Yes, and I think that was actually sort of echoed by the judge in this case, that a lot of the measures that they did was well-meaning. It certainly, there's nothing sinister there. However, they undertook a risk assessment, which the judge said was more because of COVID. They didn't really seek medical evidence. So rather than liaising with a doctor or occupational health, they were focusing in on her age and asking her about retirement. When the reality is, if you had a younger staff member who was suffering from a mental impairment, retirement probably wouldn't even have been talked about. It would all have been based on what medically the employee could have done, and that wasn't done in this case.
Is that the responsibility on an employer, is to seek to do what they can to help someone continue in employment?
Yes, it is. And if they're making the decision that someone can't continue with their employment, they should be doing it based on medical advice and going through that process, rather than just, as in this case, a knee-jerk reaction. Well, you're over the age that we typically think you should be working, so why don't you consider retirement? That's not right.
Right. Okay. So you've got to do the process these days, have you?
100% you've got to do the process, and particularly we have got an aging population. You do see people who want to stay in work. They don't just want to be sitting at home. They're more than happy to be going out and feeling useful and contributing to society. So if someone appears to be unable to do their job, and that's the key here, is that a lot of it was presumption based on what her employer and colleagues were seeing, rather than what her doctor said or what occupational health said. So they went from a position of what they felt that she couldn't do, rather than starting with actually what are this person's rights and what is their doctor saying, how can we support them, and if we can't support them, then how do we move towards dismissal, respecting this person's dignity and with compassion.
Such a difficult situation for everybody involved, though, including other staff members, because this arose, I think, didn't it, because other staff members had noticed that she was becoming confused, and there's an occasion, wasn't there, where she couldn't find her keys or a bus pass, so one of her colleagues said, let me have a look, and went into her bag to try and find them for her, and it was found that they shouldn't have done that. It's so difficult to know what you should and shouldn't do, isn't it?
It is. I mean, that's really correct. And again, the person who sort of rummaged through the bag, that wasn't so much, they weren't criticised massively. It was more that they said, well, no one asked her consent. No one asked her how she wanted support in that situation. Her bag was taken and it was gone through. And that's where the sort of that violation of dignity, rather than sort of asking her, it was the presumption again that because of her age and condition that they wouldn't know what she was being asked or what she was doing. And that presumption wasn't based on anything solid. So it absolutely has to be that there's a procedure, and, even a well-meaning act can land an employer in hot water.
Thank you very much, Alyssa Thursfield, Head of Employment Law at Gamlin's in Shrill. It's 6:42.